Final case set for argument today is James Dragon versus Gerald Dragon, 18CA0050M. There was no brief filed on behalf of James Dragon, so we will only hear arguments on behalf of Gerald. And Attorney Spears is present to present that argument, so you'll have 15 minutes. We've read the briefs and are ready to proceed if you are.
Thank you, Ron. May it please the court, Your Honor, this appeal for our position has two assignments of error. The first assignment is that the trial court erred and abused its discretion in denying Mr. Gerald Dragon's motion to continue. That motion was filed pro se. We believe that the second assignment of error flows from the denial of the motion to continue outlined in the first assignment. We'll take those in turn. Your Honor, it's interesting because the record shows that he received notice of this filing on a Saturday, the 5th. And unlike many people, he immediately, on the first business day, gets to the court to file a request for a continuance because he realizes the short time that he has to secure an attorney. What's even more interesting is that the statute in which he's filing this under, one of the two things that they tell you to look at is, one of them is a reasonable request for a continuance to obtain counsel. The court goes on through its process and through its considerations, and it talks about all the things that he failed to do. He failed to set forth how much time that he needed. He failed to renew his motion on the 10th when he came to court. He failed to separate out exactly all the efforts that he made. I would submit to this court that's exactly why he needs an attorney. The truth is, he doesn't know that he needs to do those things. But what do we know that Mr. Gerald Dragon tried? One, he was as zealous as he could be getting information in front of the court that, hey, I just got this. I really want somebody to help me that's legally licensed and trained. And I want you to get this request as early as possible so I'm not walking in here on Wednesday afternoon saying, give me a continuance. He received information late in the day on the 8th that had been denied. And I think it's interesting because how he received that was via phone call. Because the court even realizes that it doesn't have enough time to send him a written decision on that.
The 8th would have been, what, the Tuesday or Wednesday?
The 8th would have been the Tuesday.
The Tuesday.
And I think that one of the things, when we talk about the standard here, I think what the court was just unreasonable. I don't know that I see anything in here where they were being arbitrary, any of those. I just think it was unreasonable to not grant him additional time to get legal counsel when he seemed to be, in my opinion, so active in seeking that. They go forward at the hearing, and there's so many things from the transcript of the hearing that I'd like to consider myself competent counsel that would have, and in my opinion, should have been objected to. The basis for granting a CPO isn't just someone alleges something, and if they allege it and come in and testify to it, we'll grant it. There are standards at which this suggests, just like any other evidentiary hearing, that there's a reason to believe some of the information. Well, what could Mr. Gerald Dragon have done with more time or with counsel? He could have subpoenaed the people from the bank. He could have subpoenaed witnesses in his family that, frankly, his position was would not have agreed with some of the information and testimony that was there that day. There's not only hearsay, there is double hearsay. There are things that obviously he doesn't know to object to. And I think we're ignoring something also. As bad as things may seem in our society today, there are a few things that I think are still true. I think that the average person sees a uniform and a badge and they respect it. I think people hold in high regard the males and females that endeavor to wear the robe and to distinguish our laws and to make rulings. I think they absolutely respect and revere that. Even fear or are apprehensive on how they respond to rulings. When he gets the denial of the request for continuance, why should he think he's supposed to go back in and ask for it again? He doesn't feel comfortable doing that. When he speaks and the person is testifying, why should he feel comfortable interrupting and saying, I object to it? They just don't. That is why courts always want people to be represented. One of the interesting parts in the overruling the objections was that in one part it says if the person, he did not put a service signature, service line in his motion to continue. Again, a technical issue that every attorney knows that a layperson doesn't. But then it suggests if a person chooses to proceed without counsel, then they do so at their own peril. He was screaming in every way he could that he did not want to proceed without counsel. He absolutely wanted to be represented. It is his position that is the biggest part of this, because much of the information that the court ultimately uses in making its decision to issue this, in my opinion, is information that never would have come in under these same circumstances had an attorney been sitting beside Gerald Dragon. The court would not have heard much of that information. Much of it, our position would be almost all of it, was hearsay. And there appeared to be no corresponding argument to allow that hearsay to come in. One person came in and testified. That one person was not present when the incident or the allegations or the things that were said were spoken. He was given that information by someone who did not testify. He was asking for protection on incidents of people who did not testify that the allegations occurred. Even if you consider the truth of that, we don't know the recency, how distant this information was, these allegations were. Did it happen 2 years ago, 5 years ago? None of those things were even gleaned through his hearsay testimony that a competent counsel, I believe, would have either objected to or clearly cross-examined on.
Did the court set forth reasons for denying the motion? Were those things that you mentioned earlier?
Yes, Your Honor.
Did indicate why the time was needed, didn't renew his request?
Your Honor, in the court's judgment entry after the objection hearing, it specifically goes through, and I would suggest to the court is a very well-written, organized, and detailed entry. I just believe it actually supports the position that he should have been given time. Not necessarily cuts against it. The court says.
Okay, before you get there though, was there an entry created and filed when the original request was denied prior to the hearing, where the court set forth its reasons for denying the request? And then I'll hear about this other one.
Your Honor, yes, I believe that there was an entry concerning denying the motion, but because it was such a quick date, he found out about it through a phone call, a courtesy phone call, because the clerks knew they could not get that information.
Did that entry set forth the reasons for denying that request? I understand he got it the Tuesday before the Wednesday hearing, or at least was notified by phone. But And if it's in the record, I'll find it.
Yes, it's in the record, and Your Honor, just to be very direct, I do not know exactly what the reason set forward. I do know that the reason set forward after the objection hearing
All right, that's where you
were very well vetted, very well vetted. And frankly, it says many things that our position is, it actually helps because it alleges he failed to do things that if a person had chosen to proceed without counsel and they were asked, you do know in almost all of these hearings, criminal, domestic, any, you do realize that you have a right to counsel, you have a right to have somebody with you, you're okay with proceeding. All those things are said. That individual then has to accept or has to deal with their failures in a very different way, in our opinion, than what Mr. Gerald Dragon should have, because he is saying, I need an attorney. I have had very little time. And they're ignoring this. Him asking for an attorney is one half of that process. Because you can call 20 attorneys. If all 20 of them say, I can get you in on Wednesday, or I can get you in on Thursday, or they don't call back, his panic over that 24, 48, 72-hour period wasn't just he had that hearing, he was placing phone calls, not getting phone calls back, or people suggesting...
Well, that's not in the record, is it?
No, Your Honor. But I would submit the scenario of what he tried. He did not realize that that was something he should have put on the record the morning of before they started the hearing. All those efforts, all the things that he did, what he was concerned with, he had no idea that that's what he was supposed to tell them. Again, if he had had an attorney, even if he had had some advice or had been aware, he had gone through processes like this before, maybe he would have that knowledge. Unfortunately, because of the short, and look, the fact that he got it on Saturday versus Friday or Thursday, or he doesn't control that either. The clerk's office doesn't control it. But I think it's really interesting that the first opportunity that he gets to get to the court and address it shows something about what his motivations were in securing counsel. And if he calls, as I said, 10 attorneys, but he cannot get one or can't hire one before Thursday, that's just him. His efforts is only one half of that. Someone has to say, yes, I'll come in and represent you. Giving him additional time, it seems logical that giving him additional time would have given him a better opportunity to find an individual to come in and argue for him.
Of course, from the court's perspective, you know, the court asks, this is a request for a protection order.
Absolutely.
So delay
Does not, in this instance, harm anyone because they issued the ex parte order. It would seemingly cut against Mr. Gerald Dragon because he would have an order existing against him that he's denying for a longer period of time. In this instance, they did issue the ex parte order. It would have remained in place through this continuance. So it is our position that no one's harmed and the party remains fully protected through any period of time that the court would extend this.
All right, thank you. You got about a minute left.
Thank you. Based upon that, we can't look into the court's mind. We have to look at the record and some of the information. But it would seem to me that this is an instance that cries for a reasonable continuance for someone to get competent and licensed counsel. We believe that it was unreasonable for them to do that. We believe that because of that, much information came in. We believe that the information that did come in still was not sufficient to support the finding, we would ask the court respectfully to uphold these two assignments of error, to reverse this and order a judgment entry that they have to rehear the full hearing, Your Honor. Thank you for your time and attention. And that's all.
Thank you very much for your argument this morning. Very serious. The court will take the matter under advisement, issue a decision in due course, and the clerk of courts will mail you a copy of the decision, as well as to James Dragon, once the opinion is released. Also, the opinions are posted on the Supreme Court of Ohio's website. That is the last argument for today, so we will be in recess.